All right, everyone. I'd like to thank you for joining me for episode 2 of Axe Synergy. I have the distinct pleasure of having Mr. Steve Pelton with me with Foster and Pepper. So that I don't mess up his amazing bio, I'm just going to turn it over to him just to tell us a little bit more about himself, his practice, and what he's going to be discussing at the upcoming NASCA's Conference State Summit in San Francisco on August 13th to August 16th at the Westin St. Francis. So without further ado, Mr. Steve Pelton.
Thank you, Anson. Just for the purpose of full disclosure to our audience, Anson and I had a conversation maybe 2-3 weeks ago, which I expected to go about 5 or 10 minutes, and 45 minutes we were still at it. So I'm looking forward to having our conversation today and again in San Francisco. Looking forward to seeing the rest of the credit union folks at that time. As Anson mentioned, I'm an attorney. I practice in Seattle, Washington. I've been in practice for more than 30 years, the last 20 of which were here in Seattle. I'm an employment lawyer representing mostly management and companies, including a number of credit unions. I provide employment advice and counsel to management, to HR. I also defend credit unions and other employers in agency claims and in litigation. I provide preventive training for credit unions and their management and other companies as well. I also represent some individuals who have issues in the workplace and are looking for counsel and support, often when they're entering employment or when they're exiting. And finally, I've been doing a lot of work with credit union and other boards on advising them about governance duties that they have as boards of directors. My background goes way back to the 1980s after law school. And like you, Anson, I've spent a lot of time in Chicago before I came out here. And actually, I'm coming out next week to Chicago as well.
Okay. Well, we might have to link up.
Absolutely.
Okay.
I hope that I'll have an opportunity to do that.
Okay. All right. So let's jump straight into it, and I want to frame the conversation in some ways around the topic that you're going to be discussing at the NASCA's conference. Without stealing too much of your thunder, the topic is Me Too and the corner office, the credit union / regulator's role in preparing for and responding to sexual harassment claims. And just to kind of frame the discussion, just Me Too in general, has it really, I guess, bled over into the corporate space? Specifically, have you been seeing an uptick in sexual harassment claims in the credit union and banking space as it's happening at the same rate in the entertainment space?
Fair questions. Let me go back in history a little bit because I've got the history to draw back on. I can remember well in the mid 1980s when there was the Meritor savings case. That was the first federal case that recognized that sexual harassment was actually illegal under federal law. So that was that very baseline is, yes, this stuff is wrong. Before the mid 1980s, it wasn't necessarily even improper. There's been a lot of development in the law since then. That was a big watershed moment. The next watershed moment was a much more recent one, and that was October of 2017. In the first part of that month, the New York Times published an expose of true sexual harassment, including sexual assault in Hollywood regarding a guy named Harvey Weinstein.
Okay.
And that galvanized an entire social media movement. There was more attention paid to sexual harassment, not just in Hollywood, not just in the entertainment industry, but in industries across America. And that was, life really changed for me and for many Americans after that time. We had the great social media movement of the Me Too, where, again, it was a galvanizing sort of event where people who had been silent for many years decided that this was time for them to tell their stories. That also precipitated a number of employment-related claims that were made for sexual harassment against employers of all kinds.
Mm.
And so we saw a substantial increase in the number of reports that were made internally by employees to HR and to companies. We also see an uptick in the amounts of claims that are making their way to court and making their way to agencies. For example, the EEOC's sexual harassment menu went up last year. There were more claims brought than in prior years. And we're seeing that in other parts of the judicial process as well.
Okay.
A number of state legislatures have gotten into the act. You probably know that the way that many companies dealt with sexual harassment in the past was to resolve things quietly with the victim, often by payment of money with a non-disclosure agreement so that it remained confidential. What a number of state legislatures have now done is to prohibit confidential settlements of that kind. So if there is a settlement, it's no longer possible in some states to keep that under wraps. And the idea being that other women who might be victims should know that there is a history here and creating additional transparency.
I got you.
I should mention, Anson, that sexual harassment and Me Too is the most visible part of the harassment issue that's arisen around the country. It's not the only one.
Okay.
We see a large number of claims brought for racial harassment,
Mm-hmm.
for religious harassment, for disability harassment, and other ways in which people are being treated improperly on the basis of their membership in some protected status, minority or otherwise.
Okay.
So those claims are still out there. Employers still have to be concerned about them.
Okay. So with that this environment, what should CEOs and boards be doing from a policy standpoint proactively to one, educate their managers on how to respond to these claims when if an employee makes one, and then also what should boards be doing from a policy standpoint in terms of preparation as well?
And great questions, and ones that I've spoken on before, including for some NASCA's groups. The traditional way that employment lawyers like me have dealt with sexual harassment is through advice when issues come up, but also through preventive training. And so I have worked with a large number of groups and individual credit unions and companies to provide them with management with the ideas about what is sexual harassment, how does it work, how do we avoid inadvertent misconduct that could result in a claim, and how do we make sure that it's a workplace that's welcoming and productive for all employees, and not with the distraction of sexual harassment or other kinds of harassment. So that training tends to push out to all management, and then members of management or HR will then push it out to line employees as well. So that's a training preventive piece that's very important, and many companies have that going on now.
One topic that honestly I can say personally was difficult for me to understand, and I took one of my fraternity brothers who's a psychologist explain to me is the concept of power dynamics and how they apply in the workplace when someone that's a manager of someone in a higher position, either they're in a conference situation or in an after work situation, leans into an employee and asks them for something or comes on to them. That the nature of that individual being a manager asking a subordinate, that creates a power dynamic that could create a sexual harassment claim. Could you go into that a little bit further for the viewers, so just to make sure that individuals understand this? Because people go to conferences, people have work outings, and I'm not sure on both sides, both the male and if you properly understand what that means.
Sure. There's actually two different kinds of sexual harassment that's recognized by the courts and by the agencies. One is the kind you're talking about with the power dynamic, and they call that quid pro quo, which, if you recall from your high school Latin, means this for that. It's offering or trading sexual favors for job benefits.
Mm-hmm.
And almost always that's somebody who has authority and power over someone who has less authority or power. Often it's extorting or extracting or attempting to create a relationship that is unwelcome to the subordinate person. So that does happen. That's very common in some scenarios. I think it's less so than it used to be. And so the kinds of situations you're talking about with the power dynamic, very important. That's only one of two kinds of sexual harassment, though. The other kind, and you hear this word all over the place, is the hostile environment sexual harassment.
Mm-hmm.
And hostile environment has so many colloquial meanings at this point that it's lost some of its legal meaning. What sexual harassment is from a hostile environment perspective is conduct of some kind that is sexual in nature and is either severe or pervasive and which causes harm to an individual.
Okay.
So the important things there are severe or pervasive. So pervasive means that if there's a workplace that is toxic because everyone's making sexual remarks or there's sexual innuendo or there's efforts to try to create a sexual relationship, even if there's no power dynamic, it can still be a pervasive part of the work environment and create a liability for the employer. By severe, you could have either severe or pervasive. By severe, we're talking about something that could be a single time, a sexual assault. That could be enough to be a hostile environment, even if it only happens once.
Okay.
The most common, though, is the toxic workplace, the pervasive nature of a bad behavior in the workplace that creates liability.
So just from I like to be very action oriented and things that viewers can take away as a takeaway. So if I'm a manager, I'm still a branch manager at a branch, and Susie comes to me and says that John is in behind the teller line, constantly rubbing himself or just finding ways to brush up against her as she's passing. What am I in the first 48 hours inclined? What are my responsibilities as a manager to do in those instances in the first 40 hours from her making that statement to me?
Yeah, so that's a great question and one that comes up all the time. And you actually, as a manager, are glad that that's coming up. Better they should come to you as a manager than come to a court of law and file a lawsuit. So if there's a way to try to resolve things internally, that's going to be better for everybody.
Okay.
So the fact that you have somebody who trusts you and comes to you as a manager, that's great. Ordinarily, what you're looking at first is going to be some kind of policy that the manager should know about. And that policy would tell the manager once he receives that report what to do. But ordinarily that is taking the information you receive from the employee and passing it along to a limited number of report to individuals. Ordinarily that's going to be HR and perhaps a senior manager. And so you go, when you finish your conversation, to that report to person and say, here's the conversation I just had.
Okay.
So I'm giving you full disclosure. Then you stand down and allow HR to conduct an internal investigation, either with an outside person or with someone within HR, to gather the facts and try to determine what actually happened. Report those facts up to the decision maker, which could be whoever the branch manager is. More likely it's going to be someone in senior management, and decide what to do.
Mm-hmm.
But the important part of that is really the part that you participated in. You took the report and you brought it on to the people who know how to deal with it.
Right.
What you don't want to do is have you as the branch manager go out and do your own investigation.
Okay.
That would be undermining, and you're not trained for that. You're trained to operate your branch, not to conduct investigations.
Okay.
So great question, and hopefully that's an answer that people can work with.
No, that's sufficient. And I appreciate you. Are there any, I guess, before we close that particular section around the Me Too, are there any just closing thoughts around that particular topic around Me Too in terms of what boards should be on the lookout for, going forward?
Sure. And what I'll be covering in San Francisco is directed to the CEO or the top regulator rather than to HR or management generally or to the board. So that'll be my focus there.
Okay.
I also have presented to boards on Me Too. And for board purposes, it's a slightly different situation because I think you and I talked about this during our last conversation. The
Mm-hmm.
board role is not one of micromanaging or even managing the operations. The
Mm-hmm.
board role is one of governance.
Mm-hmm.
So in general, the organizational part that's responsible for dealing with personnel issues like Me Too is the CEO and
Mm-hmm.
is the CEO's subordinates. So I try to tell boards that in general they should not be involved in most kinds of investigations, most kinds of harassment issues,
Mm-hmm.
with a couple exceptions.
Mm-hmm.
One is under some circumstances, a board member may get a visit or a call or an email from an employee
Mm-hmm.
saying, here's something I'd like to share with you as a board member.
Right.
That board member then has to know what to do. And that's what we talk about when I do the board training. Secondly, if the CEO or some other senior manager is involved in the harassment, either conducting it or doing it himself or herself or permitting it to occur,
Yeah.
there's a role for the board in stepping in at that point. And the third thing is often boards will want to take, or in some cases, boards will want to take a public position on their attitude toward Me Too and sexual harassment in the workplace. So some boards I work with want to actually put out some sort of public statement even before there's a claim about their commitment to oppose harassment, discrimination, wrongful behavior in the workplace.
Okay. All right. Thank you for that. I appreciate that. So let's shift gears here. Mental health in financial institutions, whether we're talking about banking or in credit unions. I recently had an opportunity to speak to a group of young people at the Virginia Credit Union League, and I addressed topics like anxiety, not from a perspective of as an expert, but just acknowledging that there are individuals that deal with anxiety, individuals that deal with depression, and other kind of mental health issues, and that as future leaders, they need to be aware of that. And you'd be surprised, after I got off the stage, I had at least two people come up to me in tears saying that I deal with that. I never thought anybody would address it. And they just appreciated me from bringing that to the light. And so, from an employment law standpoint, two perspectives I'd like to hear about. One, what are some of the things as an employee can they expect or should be allowed to get if they are dealing with anxiety or depression and things of that nature that may affect their ability to work? But then also from the CEO and manager's perspective, what are some of the things that they can do to make a more comfortable workplace for individuals that aren't, in some ways, neurotypical? I might use that colloquial word, that's individuals that don't deal with some of those issues.
Great question again. In terms of what sort of resources are available, most organizations that I work with have an employee assistance program that is an outside agency, EAP. You may have heard that expression. And that's an organization that will have a hotline where if you as an employee are feeling under particular stress, you're not sure how to deal with it, you may need referrals, you prefer not to go to someone within the company, you have access to an outside expert to take the call, talk you down if it's really a serious issue, but also then get referrals for additional support.
Now, Steve, is this something that larger organizations have, or would smaller organizations? Is this a paid service or free service? Like who has access to this particular number?
It's a paid service,
Okay.
so it's something that the employer pays for. Most mid-sized to larger employers will have one, and it's I think a good investment
Mm-hmm.
because if you can take people who otherwise are severely stressed and give them an opportunity to find help on a confidential basis, I think you more than pay for it.
Mm-hmm.
So most organizations will have that, and if you're an employee who's got an issue like that, and there's a list of employee benefits, you'll often see EAP on it.
Mm-hmm.
If the company does not have an EAP, you may be able to go to someone within HR and say, "Can I get a referral?"
Okay.
And if you're not able to do that, most insurance plans now, health insurance plans, will cover psychiatric or other kinds of mental health issues as part of the regular menu of services that they'll provide to employees who need help.
So
So
one
there should be assistance.
one thing that I've noticed in terms of just some of the good CEOs and good managers I've come in contact with in the financial institution space is that they have a good sense of, although they may not be a psychiatrist or a psychologist, they have a good sense of the mood and temperament of their employees. And where I see some of these individuals have a competitive advantage in terms of talent retention, they recognize individuals that may have certain mood swings, and they give them the space they need to maybe go for a walk. They offer things like remote work, because certain things stress them out. Because at the end of the day, in my opinion, as long as the work is getting done, you can create a competitive advantage against other workplaces if you're willing to accommodate certain individuals that run into these issues. Yeah, you have any thoughts on that?
Absolutely, and I do a number of presentations on, and this comes into Americans with Disabilities Act, the ADA,
Okay.
which protects qualified individuals with disabilities, and those disabilities include mental disabilities. Most states also have similar protections for employees as well. So it's well established in virtually all workplaces that employees who have mental or physical problems that interfere with their ability to work may have the opportunity to get the kind of accommodations that you're talking about, a change in work schedule, a change in work location, the opportunity to take a break more often. So there's an entire process that happens when someone comes forward and says, "I have a problem, I need some help," and then there's an entire set of processes that go on from, and the HR ordinarily will guide this to determine whether this is a person who has a problem that we can work with, whether there's some part of the job that needs to change or can change, what sort of accommodations may be possible, consistent with the employee's need to actually do the job.
Right.
And often these accommodations are very effective. I've presented along with engineers and other people who work on workplace accommodations. And I don't have the statistics in front of me, but most workplace accommodations of the kind you're talking about are free. They
Okay.
don't cost the employer anything. Others, there may be a slight initial cost, less than $500, and those accommodations often are highly successful. And so sometimes something as simple as moving someone's workstation
Mm-hmm.
or providing a different schedule or a whole different range of things depending upon the needs of the individual can be very effective at making the person productive, healthy, happy on the job. Now, you can't always work that way. There
Right.
are times when the problem is so severe or the needs to change are so substantial
Mm-hmm.
that it's not really possible to accommodate. And the employer needs to try,
Right.
but it doesn't always work, but often it does.
You
And
know, it's
so,
interesting. It's interesting because the doors swing both ways in the sense that if you have a person that's extremely anxious and they're your loan process auditor or something, the reason why you have a low amount of exceptions is because they're anxious about it and they're intense. And so it works to your benefit when you have an audit because you don't have any exceptions because this person has this very anxious personality. But on the opposite end, if a manager comes and just dumps a boatload of work on them unexpectedly when there was an opportunity to give them some lead time, they may blow up. They may be intense, that kind of thing. So you got to take my opinion. I'll speak for myself as a consultant. I find that you got to take the good with the bad sometimes. That door swings both ways, and so there's ways that you can map to that individual's needs. I think the day and age where an employer can say you need to get on my program, work the way we want you to work. I think that's ended in the sense that employees have a lot of more options, especially good employees, to go other places. And I think again, you can have a competitive advantage in this talent pool if you're willing to accommodate.
Yeah, and I think that what you're talking about may not even be a disability. It may just be a personality quirk.
Okay.
And so some of what is really strong management is being able to work with people who have all different kinds of work styles. And for some people, a particular focus of the kind you're talking about, where they're very intent or intense, that just may be the personality. That there may be nothing wrong psychologically or mentally with a person like that, and they may be highly productive. And being able to work with people who have all different kinds of personalities, that's what makes it a successful manager. One thing that managers have to be aware of is trying to diagnose,
Oh,
putting themselves in some sort of mental health lens that they don't have, and I don't have certainly, the degree of a psychologist or psychiatrist or medical doctor who can look at someone, get medical information, and make conclusions, or make conclusions even without evidence. And there's a protection for individuals in the workplace who are erroneously believed to be disabled or have a disability, because that could also hurt their career, as you might imagine.
correct.
If the employee is seen as somebody who has mental health problems, when in fact there's nothing wrong with them, they're also being disadvantaged, and the management has to watch out for that.
Okay.